Welcome to day one of hearing stream 3, dealing with the rural zone. We proceed with formalities. I'll ask the full to stand and undertake the karakia.
Mai te paemonga, raro ke te tai. Mai e te awa tonga, raro ke te awa raki. Te te hapori, awhi ai tarataki. Whano, haere mai te toki. Homi e, puie, tai ki.
Kia ora. Welcome everybody. My name's David McMahon. I'm an independent hearings commissioner based in Wellington these days, and I'm the chair of this 9-person panel. Quite intimidating for those sitting in the gallery. Let me assure you that won't be the case. We're running a fairly relaxed proceedings, a little bit of formality that's brought about by the structural proceeding. As I said at the beginning, this is hearing stream 3, and it deals with the rural zones. The first two hearing streams dealt with strategic objectives and district-wide matters, and hearing stream number 2 dealt with the urban areas and open space zones. We've now received the officer's final rights of reply on both of those hearings, and the panel have commenced deliberations on both of those topics. However, final decisions on all hearing streams won't be delivered until the end of the process, sometime after May next year. I think it might be appropriate for those that are in the room and those that are on audio visual, if we just do a brief introduction as to who comprises the panel, and I'll start with my deputy chair to the right.
Kia ora, Robin Cherry Campbell, Deputy Chair, Commissioner and Councillor for Carlton District Council.
Kia ora, Brian Della, Commissioner and Carlton District Councillor.
Tēnā koutou katoa, ko kere ona Naira Singh taho, Hearing Commissioner, and Ngāti Kahungunu ki Wairarapa Representative. Kia ora.
Kia ora.
Tēnā koutou, ko Jo Hayes toko ingoa, Hearing Commissioner also, and Representative for Rangitane iwi. Kia ora.
Thank you, Joe.
Alistair Plymmer, Commissioner from South Wairarapa District Council.
Kia ora, Brian Jefferson, representing the South Wairarapa District Council.
Kia ora, Fraser Marman, Marsden District Council.
Commissioner and Marsden District Council.
Thank you. And from the staff, Mr. Horrell.
Morena, my name is Charles Horrell. I'm a consultant planner for Boffin Miss School, and I am the reporting officer for rural topics.
Yes, and perhaps one of the most important persons in the room, Ruth.
Ruth, I'm the hearings administrator for the Mine District Plan.
Thank you, Ruth. Thank you for your efforts to date leading up to this hearing. People in the back row, Mr. Abraham, I recognise you.
Morning.
You're sitting in this morning and you're presenting this afternoon?
This afternoon, Commissioner, that's correct.
Thank you. And just down the back row, can we just have introductions, please?
Kendall Hammond.
Thank you, Kendall.
Alice Malone, Intermediate Resource Planner at Marsden District Council.
Thank you.
Adams, Planning Officer at Carlton District Council.
Thank you.
Morena, Solitaire Robertson, Planning and Regulatory Manager, Carlton District Council.
Hamish Wesley from Boffin School, Planner Assistant Council with Plan. Morning, Russell O'Leary, Group Manager, Planning and Regulatory.
Morning, Russell, and I think I saw Christine hiding. Hi, baby.
Sorry, Steve.
Thank you very much. As most of you know, the way these proceedings operate is that all of the material is being pre-circulated. That includes the very long and comprehensive 42-page report and all of its attachments, 300 pages, Mr. Horrell. The Horrell has also produced a summary statement that's on the web page, which summarises the main issues in response to some of the expert evidence that's been received post 42A report. Thank you for that, Mr. Horrell. So we'll hear from Mr. Horrell. He'll take us through a summary statement and we'll have questions for them. We've allocated the entirety of the morning for that. And even if we don't take that time, we won't begin from you, Mr. Apin, until 1:30. Certainly plenty that the panel can do if we have some time up our sleeve. Following Mr. Horrell's presentation, we'll move on to the scheduled matters, starting with Mr. Aburn, and that'll take us through to the end of today, which is Meridian Energy, and then we will commence tomorrow at 9 a.m. Mr. Tomlinson kick us off, and we end with Elizabeth McGrady around 2:45 p.m. At that point in time, we will adjourn the hearing. It's possible that we might have identified either some further information from officers or submitters that will put us in our deliberations, or it may be that there's some scope for some joint witness conferencing between the parties if that's necessary. It certainly was something that we, as a panel, identified in hearing stream 1 and 2, particularly hearing stream 2, with, I might say, some considerable success. So we've got that in the back of our mind also. Once we've received all the information, there'll be an opportunity for the council's 42A officer to file a final reply. Christine, would you mind just turning that off, please? Thank you. And that will be some 3 weeks after the close of the hearing. And then we'll move on to hearing stream 4, which is the Murray purpose zone. Any questions? Any procedures arising from that? Okay. If that's the case, then I'll invite Mr. Horrell to take us through your summary statement. Mr. Horrell, there'll be some generic questions and clarifications along the way. We are particularly interested in some of the background to the way the rural lifestyle zone and the subdivision standards have been derived. Leave it to you as to how you want to respond to those in terms of any context prior to your written summary.
Okay. Maybe I can go through the appendices. I'll read up to the appendices in my statement, and then we can go to those and go into a bit more detail of each of the topics that would work best for you.
That sounds fine.
I might just start by noting that Miss Juliet Chambers is online from Ag First, who I'll be relying on for the MPS for highly productive land discussion. But I'll just start my statement here. So my name is Charles Horrell. I'm an Associate Principal Planner at Boffa School. I've been engaged by the 3 district councils to assist in the district plan review. I've been involved in the district plan review and the proposed district plan since the commencement in 2020, and I've led the rural topic since the beginning of that process. I prepared the Section 42A report and the matters relating to the rural topic. My qualifications and experience are set out in that report. The rural topics consist of 2 zones, the general rural zone and the rural lifestyle zone. The general rural zone seeks to enable primary production activities and a range of other activities that require a rural location. The rural lifestyle zone, located north of Marston area, predominantly provides for rural lifestyle and small primary production. The subdivision chapter includes various policies and rules that relate to subdivision in the rural zones. In my Section 42A report, I split the rural topic into 3 parts. For the purpose of this hearing statement, I'll continue to use those 3 parts. So that's part 1, which is the general rural zone, and that includes the definitions. Part 2, which is the rural lifestyle zone, and part 3, which is the rural subdivision. I've provided a summary of each of those 3 parts and the associated provisions in appendices 1, 2, and 3. And I might just go to those now if that would suit, just to give that further context
Indeed.
So that begins on page 20 as Appendix 1. So the general rural zone, so were you, would you like more of the context to the identification of the zones first, or just each of the zones, and then we can maybe go into that?
Just each of the zones to start with.
Okay. So the general rural zone seeks to enable primary production activities and enables a range of activities that require rural location. The general rural zone consists of 7 objectives addressing the zone's purpose, rural character, providing for primary production, management of other activities that require a rural location, reverse sensitivity, and protection of highly productive land. The general rural zone contains 9 underlying policies addressing the compatible and incompatible activities, rural character, appropriate and inappropriate subdivision, quarrying activities, reverse sensitivity, versatile soils, and highly productive land. There are 2 relevant overlays or definitions that apply to the general rural zone. So there's the Martinborough soils overlay. So this identifies land directly adjacent to Martinborough that is suitable for high value crops and is vulnerable to development. The overlay limits the number of residential units per site and also limits small lot subdivision. Highly productive land. So this identifies the extent of highly productive land defined in the National Policy Statement for Highly Productive Land. The overlay applies additional limits on non-primary production activities and does not provide for small lot subdivision.
Just a couple of questions for the benefit of the panel and those online. In relation to the Martinborough soils overlay, can you just remind the panel what the predecessor to that was in the operative district plan?
In the operative district plan, there was effectively 3 rural zones. So there was a rural primary production zone, rural conservation zone, which that is now the open space zone, the natural open space zone. And there was a rural special zone, which was effectively land use capability 1 and 2 soil, and then also some additional lands that was identified for other reasons, if it was flood prone, if it had infrastructure. So the predecessor was largely the rural special zone, which applied an additional restriction on subdivision in particular.
Yes, and was the rural special zone wasn't limited spatially to Martinborough though?
No, that's right. So I guess the Martinborough soils overlay, it doesn't identify all land that has those characteristics. It only identifies the Martinborough area as that's the area that's most vulnerable to development. So it's that hard urban edge, if you like, between Martinborough and the productive land. And I guess the intent of that is that viticulture in particular really promotes the vibrancy and vitality of that town, and to compromise that to unproductive use or inappropriate subdivision would be detrimental to that.
Yes. In your 42A report and later in your summary statement, you talk about 2 functions of the soils overlay. Can you just remind us of what those are?
So that is in relation to 1, protecting the existing land use, but then also the buffer areas that surround that. So I guess if you were to identify primarily the existing land use, it would be fragmented. It would not be a cohesive overlay. So the buffer areas are required to ensure that there isn't potential for intensification directly adjacent to those land uses and potential for reverse sensitivity, which would be the main concern there.
Thank you. Has the spatial extent of the soils overlay as it relates to Martinborough changed between the rural special zone as it applied to Martinborough and the soils overlay in the proposed plan?
Yes, it has. So in some ways, well, it's reduced as it doesn't include all of that land that takes the river. I guess that if you know the area, the special zone tended to take the river valley a bit more and hug that side, whereas it didn't come as close to the town. So there are some parts that expand further for the Martin Bristles overlay than the special the rural special zone, whereas in other parts it doesn't extend as far. It's more just the area immediately surrounding Martinborough.
Are there areas of land use capability 1 and 2 in the Martinborough area that are outside the soils overlay?
I would have to check that, sorry, but I won't assume. I would anticipate there is, but I can confirm that if you'd like.
That would be useful, and I think Mr. Wesney might be recording some of the questions that we pose along the way, and we'll do a rain check on those at the end of the day. The second question I had related to the highly productive land, and you described it as the second of the overlays. So it's not as simple as that. What's the spatial relationship between the highly productive land overlay and the rural zone, general rural zone? Are they one and the same, or is the overlay a subset of the rural zone?
The overlay is a subset, so it's, and I guess when I was reading that, I did correct myself that it's not actually an overlay.
No.
It's a definition.
Yeah, okay.
So it's derived directly from the National Policy Statement.
Dealing with class 1, 2 and 3 land.
That's right, yes. Something to note with that is that will change once the Regional Policy Statement has identified the spatial extent. It may decrease, it may increase, but that will be a separate process. In terms of the land that it covers, it's, I think I did have a proportion of the general rural zone, but I don't know if I've got that on hand.
Okay, well, can identify that as, that would be, if that's of interest, identify that as another question to follow up. And how does the plan user know whether their property in the rural zone is affected by the HPL classifications?
It's it's currently identified in the planning maps. So land use, the highly productive land as it's currently identified is based on what is that? Ms. Chambers may be able to correct me on that one there, but I think it is the Manaaki Whenua database. So it's based on LUC 1, 2 and 3 based on that current extent. The web map in the planning maps, it has identified that as a layer.
Okay.
Previously, the definition did have a note to suggest that it was identified in that. I've since removed that, given it is misleading, as it's not an overlay, it's a definition. But for the purposes of plan users, there will still be a layer that plan users can see and identify if their property is within that.
Okay. Yes, absolutely.
Yeah, thank you. Just how were the planning maps developed? What's the robustness of them?
In terms of the highly productive land?
Highly productive land, yeah.
That has primarily been based on the data from the national database. I couldn't comment on the robustness of that, but my understanding is that it is high level. It doesn't go to I guess you could do soil sampling and find that there's more nuance than what that mapping does. But in terms of how the NPS highly productive land is implemented, that's the database we have to use.
Because you will have seen from a lot of the submissions, they question whether they're 1, 2, 3 or alternative. If we're going to impose this, there needs to be a bit of robustness around the accuracy of this, for want of a better term. So how do we satisfy ourselves that this is a robust process that we're following?
Maybe that's a question for Ms. Chambers.
I guess I would. One point I would put to that is that this is national direction, and it's particularly directive It's probably one of the most directive national policy statements we have. It says you must avoid. It gives very specific exemptions for when you can allow. And it's very specific on it has to be 1, 2, or 3 LUC at this stage.
That in itself adds to my question. It says, if we must avoid, we need to be satisfied that there is robustness around what we must avoid.
Yes.
Doesn't it? Does that logically flow?
Yes, absolutely. Yeah.
How can we be confident that the maps are accurate?
I might ask Ms. Chambers to respond to that one, but I do believe there's also case law behind that as well, a recent case law that can clarify that.
We asked Ms. Chambers to respond. You've talked about the HPLB directive and requiring the council to give effect to the objectives and policies of that national policy statement. Using existing knowledge and data at the national level. There's also, you also mentioned that there's a procedure for the remapping of LUC 1, 2 and 3 involving the regional policy statement. The regional councils are required, not sure within a certain time frame, but are required at the time of their next review of their regional policy statement to identify and map HPL land. Is that correct?
Yes, that's right.
And do you understand what the time frame for that process is in the Wellington region?
In the Wellington region, I don't think we've had direct comment from council. I've got my national policy statement here, so I can look at the timing for.
There are timing obligations on territorial authorities once the regional council have undertaken that exercise and
yes,
notified and made operative their mapping of their land, but I'm not sure that there's a requirement on timing.
I think you're right.
But maybe that's something we could check, Mr. Wesney. Ms. McEwen, Miss Chambers. I saw you pop up there briefly.
Yes, yeah.
Good morning.
Morning.
Can you hear us okay?
Yes, I can.
Good. There's been some generic questions, Ms. Chambers, about the veracity of the data underpinning the identification of LU 1, 2 and 3 land in the combined district. Are you able to talk to that matter?
Yep. So it is, the best data that's available for that mapping at the moment. And as Charles alluded to, it's what the policy directs must be used. And that's, there may be some, discrepancies when you get to a smaller scale into the accuracy of that LUC information. And I guess that's where your regional council comes in with their more detailed mapping. But it's when you're getting down to, small areas, less than a hectare or less, you're always going to get some degree of inaccuracy, I suppose. But yes, that's where experts can come in to argue for or against, I guess.
Yes, thank you for that, Ms. Chambers. For the data set that relates to the combined districts in the Wairarapa, what was the origin of that data that's now in the national database?
That is off the Manaaki Whenua website.
Yep. Yes, sorry. Poorly phrased question by me. What I was trying to ascertain is when was that information first collected and by whom?
I think I'd have to recall. I mean, it's been a resource for some time. So an initial work that we've done for Wairarapa, we've used that back, last year, but that was already in place then. So it's not a new resource or
No.
maps.
Some submitters have suggested that the data is quite dated and it dates back to the 80s and possibly the prior to when departments such as the Departments of Science and Industrial Research and MWD and those pre-corporatized government departments were charged with collecting that information and producing the classification system. Is that your understanding also?
Yes, but it has been updated in some areas.
Okay.
Yep.
Have those updates extended to the Wairarapa districts or not?
I'm not 100% sure of, the exact updates over the area. I could find that out though, if that was of interest.
Well, we would like to know that, yes. It's been a very sort of serious, well, not allegation, but submission put forward that this data is aged and old and wasn't necessarily based on an empirical and robust information collection stage. It was largely desktop supplemented by ground truthing in occasional instances. And I'm just parroting what some of the submissions have said. Be that as it may, though, Mr. Horrells made the point that the HPL or EPS directs that information be used, if you like, in the interim until the regional policy statement includes that mapping at a later stage.
Yeah. And there's also been a court case earlier in the year that set that precedent around that, having to use that LUC information.
Yes, that was the Targo case, I think. Judge Stevens.
Yeah, but yeah, there was, because this kind of has been a topic, that many councils have grappled over the country of whether, the accuracy of it and whether it can be used down, whether further mapping can be done or whether that data has to be used or maps have to be used in the interim.
Yes.
Sorry. So the understanding that the LUC map takes precedence over the physical looking at the site currently?
In terms of what is highly productive land or not?
Yeah.
Yes, because there was some arguments there, pre that court case that some people would go on site and say, no, that is LUC4, therefore not HPL. Whereas now if it's classed, at mapping level as 1 to 3, it is HPL. And you can use the policy in certain cases if that is not necessarily correct to argue, if there's certain limitations, I suppose, with that land.
So how does...
Sorry, supplement.
Karen, okay.
So how does it work then when you yourself and your expert information around the Gordon Street have said the exercise indicated that LUC mapping is limited in its accuracy? So how can we use something which you yourself have said is inaccurate and then take it as being, I'll use some as being gospel? I struggle with it.
Well, it's the best information that is there, and it's what the policy directs we have to use.
We'll come on to Gordon Street directly. We're dealing in the more general realm at the moment.
Sorry.
Yes, could I ask, Mr. Horrell, when were the Mount Barrow overlays last assessed, do you know?
In relation to the proposed plan overlay. So that was identified during the draft plan process in consultation with the Wairarapa Wine Growers Association. There was some slight adjustments between the draft and the proposed, but it was largely retained as initially identified, and that was what was proposed. So it's remained since. So that would have initially been identified in 2022, and has largely remained the same since.
No, I just want to clarify. Thank you.
Yeah, thanks, Mr. James. Could I just go back to the maps again? It's the plan when we approve this becomes a point in time, right? Are the maps a point in time as well, or are they able to be adjusted as information becomes available outside of the plan, or do we have to do plan changes to adjust the maps?
Yeah, I can answer that. So I guess the intent that we took was that it could evolve over time. So we've directly cross-referenced the definition from the National Policy Statement. So if that does change, the mapping would also change. So even if the interim definition changes, I think there's been signalled that LUC 3 may be removed. If that is to be removed, the mapping would also change. There would need to be a Schedule 1 process to do that, or a plan change process. Equally for the regional policy statement, once that's identified, that would supersede the existing as it.
So then if a landowner wishes to challenge the map, it's not going to be a plan change, it's going to be just dealing with the underlying data, or for a full plan change?
I guess if a landowner was to challenge the data, at this stage we have to go with what the National Policy Statement says. So it would, the higher level data would trump that. I guess what that would mean in reality for a consent application is if they have done further studies and identified the land as less productive, that would assist in justifying that it doesn't have productive use and it meets the exemptions of the National Policy Statement.
Okay.
I think from Mr. Wesney, if we could have a little bit of an update on the Otago case that Ms. Chambers referred to. I understand it is the latest on the topic.
And it's in relation to site specific, property specific,
yes,
and how that relates to the National Policy Statement.
Yes.
Yeah. And perhaps how somebody might go about actually changing that data or challenging that data as opposed to challenging the plan.
There's two different questions. The second one's the process and the ability in light of that decision to do that compared to the RPS-led approach. Okay, thank you. That was a little bit of a slide, but I think really useful understanding. Just to complete that before you go back. Just in terms of subdivision standards, can you just remind the panel, is there any difference in minimum allotment sizes in the general rural zone for those sites affected by the HPL classification and those that aren't?
Yes, so the minimum lot size within the full general rural zone is 40 hectares. So that doesn't differ between whether it's over highly productive land or not. The main difference is the provision for small lot subdivision, which is on properties, this is in Carterton and South Wairarapa, but properties less than 4 hectares, they are limited in their ability to subdivide over highly productive land. So I guess the properties less than 4 hectares may be able to subdivide an additional 1 or 2 lots, but only where they're not located over highly productive land.
Yes.
If they are, then there's a discretionary pathway, but there's an onus on the applicant to demonstrate that it's consistent with the National Policy Statement.
Yes.
And in the Martinborough overlay area, what's the minimum?
It's the same there. So the minimum is 40 hectares, and the small lot is also.
That then raises my next question. Then, when you made your comment that said the highly productive, the overlay is for viticulture and those sorts of things, is 40 hectares a reasonable size given the way that viticulture works? If we're talking about protecting it for viticulture, is 40 hectares the wrong size? Because I don't know, but I'm struggling to probably see anywhere where there's 40 hectares of vines in one location. So do we need to actually be a bit more nuanced? If we're going to have an overlay that's nuanced to there, should we not have that overlay nuanced to what it's Therefore,
Yes, no, that's a very valid question. So the 40 hectares does not provide for viticulture and also does not provide for pip fruit based on AgFirst's indication of what is an economically viable unit. The 40 hectares has been set as a balance of enabling rural subdivision while also avoiding inappropriate. The minimum is a fairly blunt approach of managing that, but if we were to reduce it down to say 4 hectares, which would enable viticulture, that would also enable other forms of subdivision, say lifestyle, for instance, that we're wanting to avoid. So I guess the 40 hectares does create a bit of a barrier for viticulture, but there is still a pathway as a discretionary activity for them to go through that process. I guess it's on the balance of managing the risk, that was considered the best approach. While there is a pathway, it's discretionary and there's less certainty, it still avoids the potential for, say, lifestyle or a different land use that may not be suitable in the Martinborough Sewers overlay.
We'll pick up on this issue in relation to the first submitter after lunch.
That's right.
The final question from me, you'll be pleased to hear, is during this Section 32A process, was there, and the drafting of the plan, was there any consideration to having a reduced minimum allotment in the rural zone for areas outside of class 1, 2 and 3?
Yes, yes, there was that was one of the initial options we considered during the draft plan process of a nuanced approach of applying a certain minimum to LUC 1, 2, 3, or 1 and 2 at that time.
Yes.
That was discounted on the basis of the issue, which was the fragmentation of larger allotments, so larger farms that have been cut up effectively.
We might revisit that issue in relation to some of the submitters later today and tomorrow.
Yes.
That's enough. I think probably enough interruptions for you. You were taking us through the summary of the general road zone provisions. You're probably up to the table.
Yes.
You just quickly run through that, and then we can go onto the rural lifestyle zone.
Yes. So the rule framework. It follows permitting certain activities, so buildings and structures, the demolition of structures, the relocating of buildings, seasonal worker accommodation, primary production, agricultural aviation, residential visitor accommodation, intensive primary production, conservation activities, rural produce retail, papakai and farm quarries. They are all permitted, either subject to standards or otherwise. And then they'll progressively move from there to either controlled or restricted discretionary to discretionary. Quarrying activities and motorised outdoor recreation activities are restricted discretionary. Visitor accommodation, rural industries, commercial boarding of cats and dogs, and any other activity not otherwise provided for is discretionary. Also, commercial activities up to 2,000 square metres of gross floor area. Above that becomes a non-compliant. So there's just one non-compliant at this stage in the general rural zone.
And so the general default is discretionary.
That's right. Yes.
Activities not listed and not specified as a non-complying. It's a discretionary activity. Okay. Okay, and then there's a range of standards.
A range of standards here. So maximum heights in relation to boundary, setbacks, number of residential units, intensive primary production, transport requirements for rural produce retail, on-site servicing, and relocatable buildings.
Okay, thank you. Can I ask you to move on to Appendix 2 then, the rural lifestyle zone? Just take us through a summary of that.
Yes. The rural lifestyle zone seeks to enable rural lifestyle and light primary production activities. Lifestyle anticipated by the plan is allotments down to 0.5 hectares, which would reflect low density residential in a rural setting. The rural lifestyle zone contains 3 objectives addressing the zone purpose, character and the amenity and enabling appropriate activities. There are also 3 underlying policies addressing compatible and incompatible activities and rural lifestyle character. So the rule framework is similar to the general rural zone. I might just note the ones that are different, if that would be.
Yes, please.
So the residential activities is it looks to enable them more so than the general rural. There's the addition of shout-abouts and small woodlots, which is largely to manage setbacks and impacts to other dwellings. Other rural activities have been increased in their activity status where they may not be as compatible with a lifestyle zone. So quarrying activities and commercial and industrial activities of note are now non-compliant in the rural lifestyle zone. In terms of standards, the standards are all the same as the general rural zone.
Thank you. Probably just move then on to the subdivision provisions.
Okay, so the subdivision chapter includes policies and rules that relate to subdivision within the rural zones. Those provisions seek to provide for subdivision in a manner that is consistent with the objectives and policies of the rural zones and the strategic direction objectives. There is a major shift in subdivision provisions from the operative district plan to the proposed district plan. This is mainly in response to the significant resource management issue that was identified being the loss of productive land from fragmentation of land holdings into smaller properties through subdivision. However, the provisions also seek to better enable desired rural lifestyle in appropriate locations. The proposed district plan continues to rely on minimum allotment sizes to provide for appropriate subdivision and avoid inappropriate subdivision. Generally, the proposed district plan adopts a minimum allotment size that aligns with the associated land use that is to be enabled. In the general rural zone, a minimum of 40 hectares is applied, which reflects the anticipated primary production subdivision while avoiding the potential for inappropriate forms of subdivision. The rural lifestyle zone has a minimum of 0.5 hectares, which seeks to allow for lifestyle development. Additional opportunities for rural lifestyle subdivision is provided in the general rural zone on properties less than 4 hectares in South Wairarapa and Carterton. This is intended to reflect land that is fragmented and contains little productive capacity. In addition to the subdivision of new allotments, the proposed district plan also provides for boundary adjustment subdivision and subdivision of surplus dwellings on a farm. The subdivision direction seeks to give effect to the national policy statement for highly productive land and generally avoids small lot subdivision over highly productive land. However, there remains a consenting pathway for subdivision that would not otherwise meet the exemptions in the NPS for highly productive land. So the rules, I've just outlined those in the table, but boundary adjustments are a controlled activity and move up to discretionary where standards aren't met. Subdivision in the general rural zone is a controlled activity for anything up to 40 hectares.
Greater than 40 hectares. Subdivision of allotments in the rural lifestyle zone greater than 0.5 hectares is controlled. Subdivision in the general rural zone to create additional allotments greater than 0.5 hectares on properties less than 4 hectares is controlled where it meets the particular requirements. So one of those is whether it meets the national policy statement or it's not located over highly productive land. Subdivision of a surplus dwelling in the general rural zone
on a property that's more than 40 hectares or a 40 hectare balance can be retained as a controlled activity.
Is that regardless of whether it's HPL?
That is regardless of if it's highly productive land.
Okay.
Subdivision of land in the general rural zone to create additional allotments less than 40 hectares is non-compliant where the exemption cannot be met and would be discretionary where it can be met. So that's a pathway there, I guess, for primary production subdivision less than that 40 hectares. Subdivision within the general rural zone to create additional allotments less than 40 hectares for non-primary production activities is non-compliant, and subdivision of allotments less than 0.5 hectares in the rural lifestyle zone is non-compliant.
Is there any provision for subdivision for utility allotments?
Yes, but that is, I might need to clarify that with the other provisions given. I believe that's been split out to align with the network utility chapter as opposed to the rural subdivision. So that will be responded to in the subdivision stream.
Mr. Wesley, I think question there, and I guess the follow-up question is whether those provisions are affected, those utility subdivisions provisions are affected by HPL classifications. We're hearing from, I think, Transpower, Meridian, etc. Later in tomorrow, I think.
Mm.
And you've provided a table there just to summarise that.
That's right. Yes.
Okay. That probably takes you all the way back.
Yeah.
To item 3 on page 1 of your summary.
Yes. Shall I continue?
Please.
So a total of 73 original submissions and 44 further submissions were received on the rural topic. Submissions provided general support to the provisions, particularly as they related to enabling primary production activities to occur. Generally, there were, where amendments were sought, they were to support specific outcomes in the zone, to provide for specific activities, or to change permitted levels or activities or standards. There was particular interest in the approach taken to managing the potential conflict of rural lifestyle development and other activities that exist in the rural environment. Some submissions support the approach as it conservatively protects productive rural land, whereas others raise concern over the restriction and ability to provide for new rural lifestyle development. I've read the respective evidence submitted in relation to the rural topic, being that of, would you like me to read those or are you happy for me to?
We're happy to take those as read. Yes.
So that's all of the pre-circulated evidence. And then I've also read the evidence of the tabled evidence. I respond to the further matters raised in the evidence below. All changes recommended are included in appendices 4, 5 and 6 with the supporting section 32AA assessment. I followed the same format as my section 42 with relation to the 3 parts and the key issues. So part 1, key issue 1, general matters. So the Martinborough Sewells overlay. Mr. Aburn, Mr. Milne and Mr. Porter on behalf of Martinborough Holdings Limited have sought that 10 Nelsons Road is removed from the Martinborough Sewells overlay. In their statements, further evidence is provided regarding the nature of the site and the impact of removing the site for achieving the outcomes of the Martinborough Sewells overlay. The location of 10 Nelsons Road with respect to the Martinborough Sewells overlay is shown below. That's figure 1 on page 3. Based on the evidence provided, I agree that the property is unlikely to support viticulture or other activities that are sought to be enabled by the Martinborough Sewells overlay without significant investment. However, as discussed in my section 42A report, this alone is not a reason to remove the property from the overlay. The overlay is intended to also include buffer areas as reflected in policy RUS P7 as shown below, and I've emphasised the buffer areas direction. I consider that 10 Nelson's Road would be an example of this buffer, noting that the adjacent properties to all sides are subject to the Martinborough Soils overlay. I remain of the opinion that 10 Nelson's Road should remain subject to the Martinborough Soils overlay.
Thank you, Mr. Hurrell. Just see if the panel has any questions of you on that.
Could you explain to me the buffer and the rationale for the buffer if we're talking?
Ruth, can you bring that up?
Viticulture? And are we talking because of reverse sensitivities or
Nelson Road?
It's a
sort of from the amenity perspective? Some people may well go, actually, I quite like having my property right next door to a vineyard, even though I don't own the vineyard. So there is that amenity issue that goes on there. And if you create buffer zones, then you perhaps changing the amenity lifestyle of Martinborough, for example. So I'd really like to just test the buffer.
Just see if I'm just getting Ruth to bring the image up. Santi, are you able to help?
The action, because there's a good thing.
I think maybe this image would be what it's on page 3 of my statement at the top.
Jump on Teams from here and can do the math.
You don't want me to just share my. Oh, that's
That's the image, yep.
yellowy look to it still.
Doesn't show a lot.
I wondered if we, whilst we could bring the Google image up, that would be good.
That's
As a
Yeah, maybe just push
as an aerial, as an aerial.
that better.
Okay, we may go back into Street View if we need to. Thank you.
I guess to answer your question, the buffers in the context of this submission, so there's 2 aspects to it. The first is if we go back to that image that is in my statement, to remove that section, as you can see there, it's completely covered by other areas. So to remove that would be
talk specific to this.
To generally
talk about buffers and what you achieve first, and then we might.
Yes, so I guess the 2 aspects is one, having a cohesive overlay. So to only identify specifically those locations that are of the particular land use, that the overlay would be disjointed and they'd be fragmented. There'd be parts in between that wouldn't be subject and those that are. The other aspect to it is managing the potential for reverse sensitivity. So I guess using the example of 10 Nelson Street, if another land use was to be undertaken there, say for instance a very sensitive activity, say high density residential, that could have a profound impact on surrounding productive use.
So grey, I presume, is the overlay area.
Yeah, that's right.
Okay, so if I'm using the term buffer, as most people would probably understand, buffer is the extremity of
outside the area.
Outside the area.
Yes.
Okay. This particular thing is right in the middle of it, so the buffer doesn't really apply to that because it doesn't meet the definition of, I would suggest, buffer.
I guess too.
That's why I asked the question: is what are we trying to achieve with a buffer if the buffer is on the outside of the zone?
Yes,
that makes sense.
No, it does. I suppose in my view, the buffer applies to both outside and within. So the buffer would apply from the areas that you're looking to protect. So if you did have something that is, say, directly to the north of that, it would also have to buffer within. It couldn't just have a line and then have an empty cell, if you know what I'm talking about there.
Okay. So if I take this a little bit further then, is there a buffer zone right around the extremity of the Martinborough overlay.
No, there's not a specific buffer that applies, no. There's not, say, a 50 metres sort of buffer of, for want of a better term.
Okay, so then I struggle then with the term buffer. If the buffer is to allow for that reverse sensitivity, and we don't have a buffer, then how does that argument that you've presented actually work?
That's a valid point. It may be that the direction doesn't reflect the intent of what's been indicated. I guess in my view, though, I'd remain of the opinion that to remove parts within the overlay would fragment and potentially not achieve the overall outcomes.
I'm not really interested in that particular site yet.
Yes.
So we're going to hear evidence on that particular site, but I'm really interested in how you're defining buffer and how you use that term and what does it actually mean practically for the whole overlay.
Yes.
Because otherwise we're cherry picking.
In answering that question, Mr. Horrell, can you point to any policy assistance that puts the buffer function in context? Is there anything in the policies that assist the answering of that question?
In terms of policies for the Martinborough Sewers overlay?
Yes.
At this stage, it would be primarily GRUS P7 as shown below paragraph 10 of my statement.
So that P7 doesn't, for me, doesn't give the definition of what we're trying to achieve with a buffer. Because if you asked any layperson what's a buffer, it's a setback to protect.
Yes, yeah,
the zone.
Yeah.
So it doesn't, to me, a buffer does not apply for anything that's in the zone. It's on the extremities of the zone. That's what a buffer means.
Yeah. I think asked and answered. Commissioner. Okay. Any further questions of Mr. Horrell in relation to this matter?
I'll find it.
I've got just a couple of brief ones, Mr. Horrell. Firstly, was 10 Nelson Street included in the rural special zone in the operative plan?
I'll need to check that, sorry.
Yes. Just trying to understand what transition has occurred, if any.
Between.
Yep. And maybe that the submitter can answer that this afternoon.
I can confirm it is located over highly productive lands, though.
That was my next question. Thank you. You know what the classification?
It's land use capability. That as well, but I think I did have in my section 42A, so I'll see if I can find that particular point. It's LUC3.
Okay. Thank you.
If you did have the section 42A handy, it's on page 33, directly under paragraph 1.3.
Got that. Thank you. I've read the evidence pre-circulated by Mr. Aburn in response to Martinborough Holdings Limited, who are the submitter. Aburn takes us through the history and nature of the site in terms of land contamination and existing commercial buildings on the site. And he comes to the conclusion that Nelson Street has features or characteristics that distinguish the property from the generality of properties covered by the overlay. He specifically says that half of property is occupied by a substantial commercial building, the other half containing heavily contaminated soils. And he therefore wonders whether, when you take account those site characteristics, whether the overlay is the most appropriate planning provision to include over that site. You've had an opportunity to read this. You've dealt with it in your summary, but is that something that weighed on you when you came to your recommendation?
Yes, I mean, I guess the position would be if we weren't to include the buffer areas, then that property would be excluded. So too would others that don't say have the productive value that would meet the intent of that direction.
Yes.
My opinion has been that the buffer areas is clear that it does need to include that cohesive area.
Yes.
So I agree that the Mr. Aburn and Mr. Porter and Mr. Milne have provided that further evidence that it doesn't necessarily meet the criteria of would be productive, but it is within still the policy intent.
Yes. Let me rephrase that. How distinguishable was this property from the other properties? I mean, in other words, you've visited the area. Are you familiar with the extent of the overlay and the properties it covers?
Yes.
Have you been able to identify any other properties that would be distinguishable also in the sense that Mr. Aburn suggests, for whatever reason, whether it's their current land use or the nature of their soils or contamination?
Based on the evidence that's been provided, there is evidence that there would be other properties that would be either of an area too small to be of productive use or specific soils that do not support those values. I guess the distinguishing feature between this site and other sites that I'm aware of is the level of contamination. So the level of, I guess, remediation that would be required before it could become used for a productive use, which I guess that would be the differing factor.
If the panel was of a mind to recommend the removal of the overlay over this property, what would that mean for the integrity of the overlay total?
In my opinion, you'd have to take a consistent approach with other submitters who have raised similar concerns that it couldn't be used for a productive use. So if that was the decision of the panel, I would suggest that consideration should be also given to those other properties.
Where there's a submission?
Where there's a submission and further evidence has been provided that provides site-specific assessment.
And there's only one or two others, isn't there?
That's right.
There was a plan somewhere. I just can't lay my hands on it.
See if I can find it here as well.
Your 42A, I think.
Actually, in appendices, it was appendix 7.
Page.
So that is, sorry, I don't have the pages if they're all stuck together, but yeah, appendix 7 of the section 42A.
2 seconds, I'll grab it.
3 properties.
Yes,
4 properties.
Beautiful properties.
So I guess there is one property that it was missed off that one, this map, which is if we've got the map there, may not be that.
Showing it, is it?
Not today.
Right.
These properties, isn't it?
Yep.
The other one I think that's not on it is the shooting.
It's I'll just find I did correct this in my statement, so I'll just find where that one was. That was 142 Dublin Road, which was just on the map, but the rest of them, so there would be 1, 2, 3, 4 additional sites.
If you could update that map, that would be useful.
Yes.
Could I just ask a question? If you then took these out of the overlay, what are the underlying rules that then apply to these blocks?
For those properties, so the general rural zone would still apply. I guess that the main difference is if highly productive land was to change, if LUC3 was to be removed, there would be less limitations on those properties. As it stands, as today, if you were to remove those, the same general provisions apply, the same restrictions apply, given they're also highly productive land. So the subdivision would be the main one. So small lot subdivision would be enabled. And then also specific land uses are.
So then what, 1.5 hectares residual if you subdivide off one section?
That's right, yes. The other key matter is the policy direction. So if a resource consent process is undertaken for an activity, key consideration would be given to the objective and policy. So GRAS P7 would be of particular interest in that consent process and making sure that the activity doesn't compromise those values.
Yeah.
Thank you very much, Mr. Hall. We'll now move on to next matter, which is paragraph 12.
Yes, so general matters. So Ms. Foster for Eastleigh Limited has noted a difference in the recommended amendments to the strategic direction objective RE03 that are referred to in my section 42A and the changes indicated in the right of reply statement for hearing stream 1. I acknowledge that there is a minor difference in the wording. I'd rely primarily on the recommended amended objectives provided in the appendix of the right of reply statement. I've clarified with the reporting officer that that is the correct version. Ms. Foster for Eastleigh Limited has sought a specific carve-out for the submitter's property to enable development at their land of their land at Riverside Beach. Ms. Foster has considered 3 options for providing this. Option 1, to rezone the land to settlement zone and natural open space zone. Option 2, to amend the relevant rural subdivision policies and rules to specifically provide for future urban development on the site. Or option 3, retaining the status quo. Ms. Foster indicates that her preference would be for the rezoning option and acknowledges that this may be deferred to the rezoning hearing, which is hearing stream 13. I cannot comment on the appropriateness of the rezoning request at this time, but I agree that it would be best considered during the rezoning hearing.
As does the panel.
Okay, great. So part 1, key issue 2, new provision requests, starting with the disposal of inert material. Mr. Ensor for Foldenhogen has sought a new rule is inserted for the disposal of inert fill associated with quarry rehabilitation. Mr. Ensor has further clarified that the activity would not be provided for by the broad definition of quarrying activities, as it is a form of clean fill material. I understand that the reason for this is that some of the material that be used for rehabilitation may not be virgin material, where the material was previously processed. For instance, crushed gravel. I provided the definitions for quarrying activities and clean fill material below. Those are from the National Planning Standards. In my view, the quarrying activity definition intends to capture all land use activities associated with rehabilitation, particularly given there is direct reference to rehabilitation in the definition. I agree with Mr. Ensor's interpretation that material would not be captured by the associated definition of clean fill material. However, I consider that the activity falls within what is anticipated by rehabilitation in the quarrying activities definition. I've also clarified this definition with the officers of each of the councils, and they also agree. I remain of the opinion that an additional rule is not necessary. Further to this, I note, regardless, the current rule framework would make the activity discretionary, as it's not otherwise, if it's not otherwise captured by the quarrying activities rule. And discretionary was the activity status sought by Mr. Ensor.
Mr. Ensor is online. Hopefully your interpretation or clarification of that interpretation with the officers at each of the councils might give him some comfort, but we'll hear from him on that at the appropriate time. I think that's this afternoon at 3:15.
So now moving into clean fill activities. Ms. Rosser for Enviro NZ has sought a new policy as inserted for clean filling activities. Ms. Rosser has provided further rationale for recognising clean filling activities in the Wairarapa, including their relative importance in waste management. The proposed policy reflects similar wording that was included for the quarrying activities policy, which is GRUS P5. Based on the further evidence provided, I agree that clean filling activities should be recognised and recommend the inclusion of the proposed policy, and I've included that below my paragraph 20 there. I note that there's not an associated rule for clean filling activities. That there was not an associated rule sought for clean filling activities. Currently, the rule would fall to the catch-all discretionary rule, as it's not otherwise provided for. This status remains appropriate, but given now there is specific policy direction relating to clean filling activities, I recommend that a new discretionary rule is inserted, and I've also included that below.
Yes, and Mr. Horrell, would that be a consequential amendment based on the original submission?
That's right, yes.
No one would be penalised by that? No scope issue?
No, I guess given it is already the same activity status, it's just clarifying for plan users and ensuring that there is that link between the policy and the rule.
Okay, so rather than being a default activity, DA would be a specific DA.
Specific activity.
Okay. Ross is not online, but she is presenting tomorrow. Hopefully she's had an opportunity to read your summary statement, but we'll check that with her tomorrow.
Great. So artificial crop protection structures. Mr. Hodgson for Horticulture New Zealand has sought an exemption as included in the General Rules Zone Standard 2, which is height in relation to boundary, and General Rules Zone Standard 3, which is setbacks for artificial crop protection structures. An associated definition of artificial crop protection structures has also been sought. I know that this evidence directly responds to a question I'd put to the submitter in my section 42A, being what parts of the permitted rule would not be met. I agree with the changes and the addition of the definition for artificial protection structure.
So no change to the rules themselves, just the definition.
So that would just be to include an exemption. I guess in my section 42A, I questioned if that asked for a land use activity, and I indicated that would actually be a form of primary production, which I don't consider. I consider it's already provided for. So I directed them, can you clarify what part of the existing rule wouldn't be met? Which is the setback. So I'm happy to accept that as an activity that should be enabled.
And so the change is an extension in the definition, though?
That's right, yes.
Okay. Quarrying activities.
So quarrying activities and highly productive land. Mr. Ensor for Fulton Hogan has sought that the proposed district plan provide explicit provision for quarrying activities over highly productive land. Mr. Ensor has noted that while the National Policy Statement for Highly Productive Land provides a pathway for extraction of aggregate, that's through clause 3.9, it's not clear how other activities associated with quarrying are provided for. For example, the disposal of overburden or rehabilitation of a site. Mr. Ensor's concern is that without clarifying this within the proposed district plan, that there is risk for a narrow interpretation to be to be taken that only extraction of aggregate is provided for by the National Policy Statement. While I acknowledge Mr. Ensor's concerns and that there may be practical implications to the National Policy Statement direction, I consider that this is an issue with the drafting of the National Policy Statement. I do not consider that it is the role of the district plan to resolve this. Further, I would consider that broadening the scope of the activities enabled over highly productive land would be inconsistent with the National Policy Statement.
Right. There's a little bit of a linkage here with Mr. Ensor's previous submission relating to the disposal of inert material was also for Fulton Hogan. Is the risk of a narrow interpretation of the MPS mitigated by the plan's definition of quarrying and?
No, I would agree with Ms. Ensor that there is a risk. So quarrying activities is a broad definition and does include various activities associated with it. The National Policy Statement only or expressly stated the extraction of aggregate or just the extractive activity, which may infer that the other activities aren't specifically provided for. At the moment, our direction doesn't specifically say you have to only provide for aggregate extraction over highly productive land, but it does directly cross-reference the National Policy Statement direction. So by default, if they had an application over highly productive land, it would go back to the National Policy Statement and they'd have that potential interpretation issue.
Going back to your table in your appendix, checking my notes, is the entry level for quarrying is RD, is it? Restricted discretionary.
So it's yes, so
it's not on HPL land.
So there's no requirement associated with highly productive land, so it goes straight to restricted discretionary where it's any activity, but it excludes the processing of material. If there is material processed, it goes to a discretionary activity. The requirements and the rule is that you do need to give consideration to the loss of highly productive land as a matter of discretion, and that would by default come back to the National Policy Statement. I guess to resolve Mr. Ensor's relief would likely require changes to the highly productive land policy to make that quite clear.
We don't have any jurisdiction in that respect.
That's right. But I'd be happy to hear further from Mr. Ensor if there was other suggestions of what that might be, and even to clarify that I have understood his concerns as they are.
This has come back to the conversations we've had about quarrying earlier about extracting the material out of the ground. It's not actually a useful product in that form and therefore needs to be refined into whatever product the quarrying is there for. And if it's only to extract, then it means you have to transport it to another site to then on process, which potentially goes against the very intent of trying to reduce noise, dust. You're creating bigger mess because you're going to be processing in two sites as opposed to one site. And the cost goes up and the greenhouse gas emissions go up with transport and the effect on the surrounding area and so on and so forth. So when we have a definition of quarrying that only allows for extraction, we may well be actually making it worse rather than better.
I might just clarify though, that's the National Policy Statement that has that. We've captured everything together.
Are we allowed to go further than that?
We're not. So it would only be in circumstances where it's over highly productive lands and the National Policy Statement trumps our plan. But yes, you're absolutely right. The associated activities generally need to occur directly adjacent. And I think there's a quote from the Aggregate Association that more than 30 kilometres of travel doubles the price of the aggregate, which just shows that it has to be there. It has to be close to cities, and it has to be close to where they need to put the overburden and where they need to process it.
So is there some way to resolve this?
Well, we'll take that up with his concern seems solely with the interaction between a discretionary activity for quarrying, where it's over highly productive land, and it's a matter of discretion.
That's right, yes.
It refers back to the policy in the MPS, and he's worried that the MPS policy might actually not create a consenting pathway.
That's right, yes.
Don't we have to make sure that this plan, even though it's a separate chapter, we talked about this in the previous chapter about this very issue. It seems to me like we're not joining this up.
Well, the fact that
potentially
Mr. Ansell has identified it as an issue must suggest that
he's identified the processing plant in his last evidence in the last submission.
I guess similar to the highly productive land, given we directly cross-reference the national policy statement, if there were changes to the national policy statement to broaden the activities to not just aggregate extraction, that would by default resolve Mr. Ansell's issues. So our plan wouldn't get in the way of that.
Okay. Number of matters to take up with Mr. Ansell this afternoon. Okay, take us on to definitions.
Yes. So definitions, starting with agricultural aviation. So Mr. Matic for Federated Farmers has sought changes to the definition of agricultural aviation as shown below. I refer to my response to the original submission in paragraphs 200 to 201 of my section 42A, and remain of the opinion that the current definition remains appropriate and reflects the common definition that's been adopted in various regions.
I've got a question on that, if I may. My reading of it, and I've gone back and reread a few times, it doesn't actually take into account UAVs and how our plan is worded, and bearing in mind that they are becoming more and more prevalent in industry, full stop, let alone rural specifically. Where would they fit in our PDP, or is it not envisaged as a concern? I'm just thinking of the future. I have a really, really good friend of mine's son. This is his business, and he's not in the Wairarapa, but the drones and stuff, they're getting bigger, they're carrying more, and I guess my question to you is, where do they fit? Do you think that we need to be cognizant of that? Yes.
I'll see if I can answer it now, but I may need to go back and have a look at the associated definitions. I guess the question would be if it's captured within the definition of aircraft would likely be the definition. Would have to go back and check.
He's got very strict rules around planes now.
But they're just being used so much in agriculture.
Let me, if you're happy for me to do so, I can respond to that after once.
Absolutely. If that can go.
If you would apply,
yes, please.
The definition that we included at paragraph 26 of your summary doesn't shine a lot of light on it.
No, that's right. I was like, I
guess it comes. We really need to understand: is term aircraft defined in the plan? Maybe you could.
It's not, but there was when we initially looked at the issue, there was various definitions from different statutes that come into it. So I'll have to have a bit of a look into that. It may also be a question for the Aviation Authority, as this is a common definition that's been promoted throughout the country. So,
thank you. Shall we move on to organic composting?
Yes. So organic composting. Ms. Rosser for EnviroNZ has sought a new definition for organic process composting, as shown below. I note that this definition has been modified from the version that was put forward in the original submission and now includes reference to a threshold for where it would become a rural industry. I note that currently there are no objectives, policies or rules within the rural chapters that reference organic composting. I acknowledge that the amendment proposed by Ms Rosser would clarify the threshold before it becomes a rural industry, but I do not consider that this alone is a reason to include it as a definition. In my opinion, the definition is not required. So moving into cross-reference to higher order planning documents.
Yes, I think
we can cover that one.
That would take that as
It was a noted, yep. So moving into part 1, key issue 4, general rural zone objectives, starting with objective 4, compatible activities. Mr Matthews for Genesis Energy and Ms McLeod for Transpower New Zealand Limited have sought changes to GRUS 04 to further enable certain activities that have a functional or operational need to be located in the general rural zone. The particular interests of those parties is enabling renewable electricity generation activities and the national grid in the general rural zone. Mr Matthews has sought that the objective is amended to remove reference to where they are not incompatible with primary production activities. Ms McLeod has sought an additional clause that specifically enables the operation, maintenance, development and upgrading of the national grid. Their associated changes are shown below, and that's directly below paragraph 32. Both parties have raised concern over the inferred hierarchy of the direction with primary production enabled over other activities. I remain of the opinion that the direction accurately reflects what is anticipated for the general rural zone, with primary production the predominant use. While I acknowledge the national importance of both renewable electricity generation activities and the national grid, I consider that the direction for those activities is already provided through the energy chapter and the network utilities chapter. I consider that the changes sought by Mr Matthews would significantly broaden the direction. I note that various activities would have a functional or operational need to be located in the general rural zone that could conflict with primary production. Example of that would be rural lifestyle. Ms McLeod's changes are more specific to the national grid, but I remain of the opinion that this direction is best provided through the integrated chapter for network utilities.
So, Harold, I've got a couple of questions there that take us back to hearing stream 1, where there were similar submissions by both of those submitters to some of the strategic direction objectives. That resulted in some joint witness conferencing and some revised recommendations in the right of reply. That resulted in a recommendation for a new climate change objective, recognising the role of renewable energy in emissions reduction. But it also at the joint witness level, it resulted in a recommendation by the participants for some changes to the energy chapter policy P4 and the GRUS objective 02. The GRUS one was about rural character and referring to renewable energy generation activities in terms of that rural character. Were you aware of that?
Yes, I was, and I've I accepted those changes for the GRUS 02.
And for energy P4?
I can't comment on energy P4.
It was about needing to locate these facilities where the resources are available. So in the rural context.
Yes. So I guess in terms of the changes I've made as a consequence, that was primarily the objective for rural character. In my view, the rest of the direction is best provided through that integrated chapter.
So you don't see any need for any further change to the GRUZ 04 objective?
No, I guess the compatibility of activities should already be directed through the integrated chapter.
And you've considered the relationship between GA, you see at 04 and the revised recommended 02?
Yes.
Thank you.
Okay, so shall I continue?
05.
Yes, so objective 5, reverse sensitivity. Ms Rosser for Enviro NZ has sought a minor change to the objective as shown below. Ms Rosser considers that the change better reflects the intent of the direction. So that change is to move located and designed, or it was designed and located, to move that to be located and designed, which I agree with and have recommended that change.
So are we sitting on a standard definition of reverse sensitivities? Because every time we seem to be changes, we had changes last time with solitaire. So
this is just the objective.
I know, but it's the definition of reverse sensitivities. Have we settled on a actual definition yet?
I can't talk to the definition itself, but I guess for the direction, it can differ depending on what it's trying to manage.
We've had a recommendation from the reporting officer recommending a certain definition of reverse sensitivity that the panel needs to consider.
Okay.
That was in
hearing stream 1.
But in this instance, the change is literally switching the words around so it reads better.
This is not a change to the definition.
It's just, yeah, actually objective. Yeah.
And it's about location is always the best form of mitigation.
That's right.
Design becomes the
Secondary. Yeah.
Okay, I'll throw up another 10 minutes and then we'll break for morning tea at 10:45 for 15 minutes and take it through to 12:30.
Okay, so moving into part 1, key issue 5, which is the general rules zone policies. Policy P1, compatible activities. Mr Matthews and Ms McLeod have sought changes to GRUS P1, similar to what they'd sought for GRUS 04. And you'll see that change there. And in response, I remain consistent with my reasonings for 04, that this is best provided for through those integrated chapters.
Well, we'll have some questions and we'll hear from those two submitters later in the piece. The GRUS P2 and compatible activities. Mr Enzor for Foldenhogen has raised that my recommended changes to GRUS P2 remain unclear. I note Mr Enzor questions clause B and the term fragmentation in the context of productive capacity. I've shown the clause below as I'd amended in my section 42A. I agree with Mr Enzor that the amendments could imply that the direction is seeking to avoid fragmentation of productive capacity. This is not the intent. To clarify, the intent of this direction is to avoid further fragmentation of rural land that is or could be used for primary production. This is further elaborated in my section 32 evaluation. I recommend further changes as shown below to clarify this direction. So that changes, it will now read, will result in fragmentation of land and any loss to its productive capacity. Okay.
GRUS P3, rural character. Ms Rosser for Enviro NZ has noted that I have in part accepted one of the changes sought by Enviro NZ policy GRUS P3, but are not reflected in the updated version of the GRUS chapter. I can confirm that the addition was not shown as tracked, but was included. I've corrected that, and that's shown below.
So that should be in red text in the 42A.
That's right.
Little point on that, you got 2 Ds in that GRUS P3 as well.
I did think about noting that, but but no, that yes, that will be renumbered
Yeah.
once.
Thanks, Ben.
In fact, as a new provision, it should be X at this stage, just to not confuse any of the numbering. Ms. Rosser for Enviro NZ has sought that clause E of policy GRUS P3 is amended to replace managing with controlling. I remain of the opinion that managing is more appropriate in the context for the reasons set out in my section 42A report.
Thank you.
GRUS P4, avoid inappropriate subdivision. Mr. Ensor for Hogan has sought changes to clause B of GRUS P4 to refer to primary production activities rather than productive capacity. The changes sought by Mr. Ensor are shown below. Mr. Ensor considers that the inclusion of productive capacity narrows the focus of the policy. As I understand Mr. Ensor's concerns, Mr. Ensor's concern is that the definition of primary production includes reference to land-based primary production. Land-based primary production is a definition. The land-based primary production definition is more specific than the definition for primary production, and generally limits. I've put secondary, but it's processing generally, and in the context of quarrying activities, it doesn't include specific reference to quarrying activities or quarry and mining. I think the primary production definition does. I've shown how the land-based primary production is referenced in the definition of productive capacity below, and I've added emphasis for where that reference occurs. While I acknowledge that including the reference to productive capacity would narrow this to land that is used for land-based primary production, I consider that in the context of the policy, that is appropriate. I note that the policy and this specific clause responds to the issue identified in the section 32 of loss of rural land due to fragmentation caused by small allotment subdivision. So GRUS P5.
Sorry, just before you go on to that, policy GRUS P4, is that specifically referenced in as an assessment an assessment criteria for discretionary activities at all for quarrying?
So that primarily relates to subdivision.
Okay.
So the land use activity wouldn't be impacted. It would be in a situation where a quarry, say, wanted to subdivide land for quarrying, that would not be captured.
Okay. That's P5 that you're now going to move on. That would be the main policy direction for
quarrying, yes. Mr. Ensor for Hogan has sought changes to GRUS P5 to delete reference to the effects on amenity values from the movement of vehicles. Mr. Ensor has indicated that those effects can be more appropriately managed through other methods such as roading hierarchy. I remain of the opinion that effects on amenity values from the movement of vehicles should be retained in the policy for the reasons provided in my section 42A. I note that in my original response, I observed an overlap in 2 of the clauses in GRUS P5 and recommended a change to remove the duplication. I had missed that in the updated GRUS chapter, and I've now corrected in the version attached.
You just pause there, please.
So that would be the deletion of IV.
Yes.
And the insertion of vehicles after machinery in I under clause B.
What paragraph are you in your 42?
This is in the this is in appendix
30.
Talked about the report.
Oh, my 42A report. Yes, that is. So that is paragraphs 1 to 4 onwards. So my response is provided in paragraph 133, which is on page 37 of the section 42A.
Comes back to my previous question and comment. We try to fix one problem, we create another.
Mr. Horrell, what do you think Mr. Ensor was referring to when he talks about roading hierarchy?
My understanding is that refers to what capacity the road could have. So if quarrying activity was undertaken in a particular area, it may be anticipated that the nature of the road could withstand a certain number of vehicles and anticipate, say, the amenity effects associated with those vehicles, which I don't agree. I don't consider that it would account for amenity values in all circumstances, and I don't consider it's a method that should be primarily relied on. It supports that, but shouldn't be the only method for managing those effects.
Okay. And other traffic effects, would they be covered in clause 3, where it talks about adverse noise, vibration, traffic?
That's right, yes.
So that would that include network capacity issues, safety issues, efficiency issues?
Yes. Let me bring that up.
As opposed to amenity issues?
That's right, yes.
If Roman numeral 4 is deleted as you've recommended, I see. Where does the amenity consideration relating to vehicle movements come in?
Where does the amenity? That would be in BI. Maintain the character and amenity values of the general rural zone at the end of that clause.
Okay. Is there a possibility that the words maintains the character and amenity values of the general rural zone is read solely in relation to visual screening and not the matters that come before
B.
Yes, yeah.
It actually sort of reads that it's only sighting and scale. So the sighting of them, it doesn't, to me, that doesn't read as movement. It's only the actual sighted somewhere. At BI.
We need to include that form.
That I guess the sighting and scale should still manage those effects. So the scale of vehicle movements, but I take the point though that the current wording is unclear how the second part relates. The intent is that all of those clauses are. I can further wordsmith that.
The imposition of a comma can have a major impact on the meaning of a word.
Yeah.
Phrase. So, mate, could you have another look at that?
Yes.
We understand the intent, the delivery.
That's right.
Okay, I think we might take that as the break and come back at just after 11. Thank you, everyone. Hearing adjourned until 11.